Hello everyone, welcome to Learn Law with AKP. In today's session, we are going to discuss the essential characteristics of a contract of guarantee under the Indian Contract Act 1872. In the previous videos, we understood the meaning and definition of guarantee. Now, we will understand the important features or characteristics that make a contract a valid contract of guarantee. This topic is very important for exams because characteristics are frequently asked in short notes and long answers. So, let's begin. The first essential characteristic is that a contract of guarantee always involves three parties. These are surety, principal debtor, creditor. The surety is the person who gives guarantee. The principal debtor is the person whose obligation is guaranteed. The creditor is the person to whom the guarantee is given. Let's understand with an example. Suppose A takes a loan from a bank. B says to the bank, if A does not pay, I will pay. Here, A is the principal debtor, B is the surety, bank is the creditor. So remember, without three parties, there is no contract of guarantee. Now, the second important characteristic is the existence of liability. This means there must be an existing debt, duty, or legal obligation. Guarantee cannot exist without liability. For example, if there is no loan, there is no need of guarantee. Suppose a bank gives loan to A, since A has liability to repay. B can give guarantee. So, guarantee always depends on an existing obligation. This is very important. Now, the next characteristic is secondary liability. This means the surety is not primarily responsible. The principal debtor is primarily liable. The surety becomes liable only when the principal debtor fails. For example, if borrower pays EMI properly, guarantor has no role. If borrower defaults, guarantor becomes liable. So remember, primary liability is debtor, secondary liability is surety. Now, another important feature is conditional liability. Conditional liability means depending on something. Here, the liability depends on default. Default means failure to pay or perform. So, the surety becomes responsible only when the debtor fails. For example, if A repays loan properly, B is not responsible. If A fails, then B must pay. So, guarantee works only after default. Now, let's understand consideration in guarantee. Now, let's understand consideration in guarantee. Under contract law, every contract must have consideration. In guarantee, the benefit received by the principal debtor is treated as sufficient consideration for the surety. Example, bank gives loan to A because B gives guarantee. Here, loan gives to A becomes consideration for B's guarantee. So, even though surety may not get direct benefit, the contract is still valid. Now, let's understand an important case law. In Birkmyr vs. Darnell case, one person promised that he would pay another person's debt if that person failed. Now, the question before the court was, Is this a contract of guarantee? The court observed that there is a debtor, there is a creditor, there is a surety giving promise. So, all essential characteristics are present. Therefore, the court held that this is a valid contract of guarantee. Here, the principle established: if a person promises to discharge another person's liability in case of default, it becomes a contract of guarantee. This case clearly explains the characteristics of guarantee. Now, let's quickly revise all the essential characteristics. First, three parties. Second, existing liability. Third, secondary liability. Fourth, conditional liability. Fifth, consideration. These 5 points are very important for exams. If you remember these, you can easily answer any question related to guarantee. Let's conclude this topic. A contract of guarantee has certain essential characteristics which make it legally valid. It always involves three parties. The liability of the surety is secondary and arises only when the principal debtor fails. There must also be an existing legal obligation. We also understood these principles through the case of Birkmyr versus Darnell. So remember, three parties, existing liability, secondary liability, conditional liability, and consideration are the essential characteristics of guarantee. For exams, always remember characteristics, explanation, example, and case law. Thank you. If you found this video helpful, please like, share, and subscribe to Learn Law with AKP. Stay tuned for the next topic.